Good morning, folks. Welcome to day 2 for some of you of this event. My name is James Cavallaro. I'm a professor here, and I'm the director of the International Human Rights and Conflict Resolution Clinic. I'm very happy to, on behalf of Stanford, offer you another welcome, and welcome to those of you who are here for this session and for other sessions that will go on today. I will be brief, in part because I'm standing in front of an extraordinarily talented panel. So that's a cue to myself. Comments short. But I did want to be here. I'm very happy to see a number of faces that I know as new faces. This is an exceptionally talented group of people who are brought together. So hats off to Diane and Titi for pulling together, and everyone else involved with the organization, and all of you for coming. Those of you who come from very far, bringing together a really extraordinary group to reflect on some very important issues. I would just like to say a few things, which is issues that are being addressed and the questions that are being asked, I think, are great questions. In many ways, not typical of the kinds of questions that many of us in the human rights field ask ourselves. We tend, I think, to look at criticism or potential criticism or doubts about the efficacy of human rights in any field, women's rights or any other issue within human rights. We tend to discount critiques and presume that many of those critiques are made in bad faith. One of the great benefits of the Academy is that we can take a step back from our role as practitioners or activists or have that inclination or that need or that engagement and ask difficult questions. And I think the questions that we're asking here are the right ones. We shouldn't presume that because we believe we're on the side of the angels that everything we do will advance social justice, will advance gender equality, will advance human rights. So I think we're asking the right questions, and we have the right people to ask those questions thoughtfully, intelligently, interrogate many of the suppositions and built-in beliefs that drive or animate a lot of what we do. So without more, we have an outstanding panel. I'll go to that. And I'm not sure if I should pass off to you or okay. And thank you again. Very happy to be here. Welcome, and we'll continue this conversation over the course of the day. Thank you.
Thanks again for coming here this morning. Appreciate you being here. I just wanted to take a second to introduce the moderator of our first panel this morning, Professor James. She probably does not need an introduction. She's an incredible hero to the women's movement, to women in legal education. But she's been a key partner for us through the Center on Legal Profession to put on this panel, and is currently hosting. One of our panelists is leading a social entrepreneurship program here at the law school that invites leading international activists to the law school and with our students.
And my only role really is to introduce our panelists and moderate the questions. So I'm not going to take up their valuable time with the introductions because they're in the materials. So let me just start by asking Nancy Northrop, President of the Center for Reproductive Rights, to start.
Well, thank you, and it's a pleasure to be here. The Center for Reproductive Rights is a global human rights organization that uses constitutional and international law to advance reproductive freedom as a fundamental right for women all over the world. And nearly 20 years ago, which is when we were founded, was also the same time as the International Conference on Population and Development in Cairo. And at this conference, 179 countries around the world adopted a program of action, which was the first consensus document to recognize that reproductive rights are human rights. And the Center has worked since that time to ensure that governments throughout the world are held legally accountable for the political commitments that they made at Cairo. And we do this by applying international and regional human rights treaties, as well as working at the national level, to make sure that the circumstances of women's reproductive health strategic litigation before human rights treaty monitoring bodies of the UN, such as the CEDAW Committee. And I'm going to talk today about one of the decisions. CEDAW has decided a handful of cases under the optional protocol, and two of those have been cases that the center has litigated. And I want to focus on the one that is on maternal mortality, the Levin de Silva Pimentel versus Brazil case, which came out in 2011, and use that as a case study for how to shape legal accountability and human rights protection to address maternal mortality, which is viewed sometimes at best as a public health issue and at worst as just women's unfortunate plight. This decision that came out in 2011 is part of a global initiative at the national and international levels to establish the right to safe pregnancy and childbirth. So the Levin decision came upon years of advocacy at the global level before the UN human rights bodies, as well as significant national level litigation, advocacy, and fact-finding. In the late 1980s and early 1990s, there was little political traction around the issue. Maternal mortality was seen by political leaders as an unavoidable risk of women's reproductive capacities, and largely only received attention from the international community as a public health and development concern. While governments had nominally committed to reduce maternal mortality, including, obviously, the Millennium Development Goals, not enough had been done in practice. Women were dying in droves in pregnancy and childbirth. The numbers in the 1990s, over 500,000 women a year dying in what are largely preventable maternal deaths. 99% of maternal deaths are in developing countries. The lifetime risk of dying in connection with pregnancy is about 1 in over 3,000 in North America. In Afghanistan today, it's 1 in 8. There's obviously no difference biologically between Afghani women and women in the United States. The difference is, do you have access to essential obstetrics care, and do you have access to safe and legal abortion? So the gender lens is inescapable, that healthcare and pregnancy, because healthcare and pregnancy is healthcare that only women need. When you think about it, in connection with bringing new life into the world, the only health risk that men face is maybe getting an STI in connection with sexual intercourse. But for women, the health risk of bringing new life into the world is literally the risk of death. And pregnancy is different from any other kind of health issue that you think about, because pregnancy is both a very normal, it's not a disease, it's a very normal process of life, and yet it can kill you. And the other thing that's really interesting to think about in terms of pregnancy and human rights is, without pregnancy, the human rights cannot even continue, right? It's necessary for the continuation of human life. Yet, governments continue to let women die because of their low status, because of gender discrimination, because their lives are simply not viewed as worth saving. So we felt that governments need to be held accountable to actually reducing maternal mortality, and that using the human rights framework would be an effective means of doing so. Now, some of our colleagues in the human rights field, and without question some of our colleagues in the public health field, were skeptical about taking this approach. They were concerned about litigating issues in the healthcare context, warning us to steer away from an adversarial setting. We're working with the governments, we've got it under control, we're working with the health systems. Don't intervene in what is seen as an adversarial way. But nevertheless, we felt strongly that we needed to start establishing the building blocks for real accountability, because the medical interventions, the public health interventions were known. They're available, they weren't needing to be discovered, but they weren't being implemented in ways that were making a difference for women. So we began by doing fact-finding reports, and with our partners by doing reports, shadow letters, the UN treaty monitoring bodies, such as the CEDAW committee, but also others, in which we were framing maternal mortality as a human rights violation. We also have held briefings for the UN treaty monitoring bodies to sensitize them to looking at, again, this sort of just a fact of life, since the time of Eve, as a human rights issue. And in response, several committees that monitor compliance with human rights treaties have indeed picked up the frame of maternal mortality as a violation of women's rights. And notably, the CEDAW committee has repeatedly expressed concern over the high rates of maternal mortality and discussed it as a violation of women's right to life. To continue to build on this, to continue to build on the concluding observations of the committee, we believed that strategic litigation was crucial. And we knew that it would be important to bring the case in a country where lack of resources for healthcare would not be the first line of defense. So we were looking for a country that was an emerging middle-income economy. One of our NGO partners in Brazil told us about the daughter of a teeny lady who had died in 2002 as a result of pregnancy complications. The daughter, Aline de Silva Pimentel, is an Afro-Brazilian woman and a resident of one of Rio de Janeiro's poorest districts. She went to the local hospital when she was 6 months pregnant with nausea and abdominal pain. She was misdiagnosed, given some pills, sent home. She returned 2 days later, and when she was finally seen, her condition was much worse, and it turned out that she had fetal demise. Labor was induced, but placental parts remained. As a result, Aline suffered hemorrhaging and infection. Her condition worsened to the point that she could no longer receive attention in the local clinic. She was denied an ambulance to transport her to a regional health facility, and when she finally found her own way to get there, her medical records weren't sent with her. The inadequate care continued to build at the next healthcare center. The doctors did not even know that she had delivered, and she was left largely unattended in an emergency room hallway where she died of an entirely preventable condition. Now, Aline's case was not an isolated case on the lack of quality maternity care in Brazil. Brazil's maternal mortality rates are disproportionately high for a country of its economic status, and deaths are particularly located among low-income and Afro-descended women, such as Aline. This reflects the lack of priority that Brazil has given to saving women's lives, particularly the most marginalized. So Aline's family brought a civil malpractice claim against the state of Rio de Janeiro, but by 2007, 5 years after her death, there was no resolution of the case in sight. So we decided to file a case before the International Treaty Monitoring Body. We faced challenging questions in bringing this case, and I remember posing them to the lawyers who were the lead on it. Why was this a human rights case and not just a question of medical malpractice? How can we use this case to seek not only justice for Aline's family, but to demonstrate that the failure to prevent maternal deaths and provide quality care is a systemic issue in Brazil? In 2007, together with our Brazilian partner Advocacy, we filed the first individual communication on maternal mortality before any UN treaty monitoring body. Not surprisingly, we chose the CEDAW committee as the venue because we wanted to bring this particular right to life case in a strong discrimination frame. The CEDAW committee had recognized that failing to provide services that only women need is sex discrimination. And we knew that the committee would unpack the multiple forms of discrimination that Aline's story presented: gender, race, and class. Specifically, we argued that Brazil violated its international legal obligations under CEDAW to ensure women's right to life and the highest attainable standard of health on a basis of equality with men and free from discrimination on the basis of sex. So last year, in 2011, we received the groundbreaking Aline judgment in which the CEDAW committee established that governments have a human rights obligation to guarantee that all women in their countries, regardless of income or racial background, have access to timely, non-discriminatory, and appropriate maternal health services. The decision underscored that even when governments outsource their health services to private facilities, they remain directly responsible for their actions and have a duty to regulate and monitor the private institutions. The ruling establishes that violations of the right to health and the right to access to justice and due diligence obligations. The committee noted in particular that Aline's lack of access to quality and appropriate maternal health systems stemmed from multiple forms of discrimination, which the state had failed to address. The committee ordered that the government provide appropriate reparations, including adequate compensation to Aline's mother and daughter. Additionally, it ordered the government to ensure women's right to safe motherhood and affordable access to adequate emergency obstetrics care, to provide professional training for health workers, ensure that private health facilities comply with national and international standards on reproductive health care, and that sanctions are imposed on health professionals who fail to meet those standards. In consultation with Brazilian experts and NGOs, we have produced a 150-page document for the Brazilian government, which specifies the measures it can take to comply with this decision, including policy reforms, and we're in ongoing negotiations with the government to comply. So the development of norms addressing maternal mortality as a human rights concern has impacted the broader field. Framing maternal mortality as a human rights imperative has created political space for reform at both the national and international levels. At the international level, including the work of CEDAW, the UN Human Rights Council, of course a political body, this year adopted a resolution that recognizes maternal mortality as a human rights violation and encourages states to adopt the technical guidance on the application of human rights-based approach to the implementation of policies and programs to prevent maternal mortality and morbidity. This resolution follows the adoption of 3 resolutions on preventable maternal mortality that began by the Human Rights Council in 2009 based on extensive advocacy by human rights organizations. At the local level, we've worked with national level NGOs to bring maternal mortality cases. One example is in India, where many cases have been brought before state courts. I'll mention one, the Laxmi Mandel case from the Delhi High Court in 2010. In the Laxmi case, the High Court instructed the state of Haryana to pay compensation to the family of Shanti Devi, who died in childbirth after being denied emergency obstetrics care from 4 hospitals because she was unable to pay the fees. Drawing on both national and international law, the court noted that the cases demonstrate a complete failure of the public health system and the government's implementation of programs designed to reduce maternal mortality for women. India has very good policies on the books about maternal mortality, including good policies about paying for care and getting women to the hospitals, but they're completely not followed. So again, the need for accountability by the government, some kind of way to bring a lever to the government to actually live up to their policies. The court also ordered individual reparations for Shanti Devi's husband and a trust for her children. And it ordered systemic remedies, including providing cash assistance for pregnant women below the poverty line, setting up health checkups in rural areas for pregnant women, and improving the system of providing safe and prompt transportation for pregnant women. The Aline decision, together with a broader advocacy and litigation strategy to develop international human rights standards around state accountability for preventable maternal deaths, has created political space for reform in countries throughout the world. Again, turning back to Brazil, Brazil is concerned about its perception among the international community as a violator of human rights. Thus, it's been willing to enter into discussions with us about the implementation of the Aline decision and has taken some measures to implement aspects of the decision. They have convened an interministerial working group that's charged with addressing various aspects of the recommendation of the CEDAW committee. And Brazil has agreed to provide individual reparations to Aline's family and take symbolic measures in the forms of issuing a public apology to the family. And while the CEDAW committee's recommendations in the Aline decision, of course, were made only to Brazil, they can influence law and policy making on maternal health in decision has created a platform for publicity regarding the state's obligations on maternal mortality, which in turn can promote social mobilization in other countries and empower individuals to use different accountability mechanisms to demand state action. It can also provide guidance to other treaty monitoring bodies, regional human rights bodies, and domestic courts on the application of human rights in relation to maternal health. And in the past year, since the decision came down, academics and advocates have cited extensively to the Levin decision, encouraging governments to adopt a rights-based approach to combating maternal mortality. So strategic litigation before the CEDAW committee, such as in the Levin case, can help create the political space for reform in particular countries to promote structural remedies and far-reaching changes in laws, policies, and practices to improve access to quality services related to safe pregnancy and childbirth, and hopefully to move from women's inevitable condition to her right to have a safe pregnancy and delivery. Thank you.
I want to share with you the research project that we did. My group, let me just quickly introduce. Citizen Islam is an NGO based in Malaysia that works on women's rights in Islam and basically challenge the use of Islam to justify discrimination and maintain discrimination against women. And we've been around for over 20 years, and because of the groundbreaking work that we've done in working on religion from a rights perspective, there's been a lot of international interest in the work, and this really led us then to launch Musawa, which means equality in Arabic, a global movement for equality and justice in the Muslim family that brings together activists and scholars working in Muslim contexts on issues of equality and justice and reform of discriminatory laws, bring together to really create a public international voice of Muslim women demanding for reform and for justice and equality. So we have different aspects of our work, knowledge building work. We're doing a huge research project now on the whole issue of male authority over women in Islam, the myth of the male provider and protector, and really unpacking that and challenging that. That's still work in progress. And the other area of work that we're doing in a big way is the international advocacy work. And we started with CEDAW because the women's groups in Muslim countries basically recognize CEDAW as the most important international human rights instrument that they use to pressure the government, push the government in terms of changing laws and practices that discriminate against women. And of course then, you know, we all come against the brick wall of religion. If you look at the reservations that countries use, the OIC is Organization for Islamic Cooperation. So it brings together Muslim majority and also some countries in Africa in particular with minority Muslim population together in this grouping. And so we looked at documents, massive amounts of documents from 40 OIC member countries and 2 non-OIC countries with significant Muslim minorities. And we reviewed all the state party reports to the CEDAW committee, the list of issues that the CEDAW committee sends back to the government, the summary records of constructive dialogue between the CEDAW committee and the governments, the concluding observations, and the shadow reports submitted by NGOs over the past, between 2005 and 2010. So it was like, and what we wanted to do was really to analyze and critique how governments use Islam, Sharia law, Islamic law, the language that they use to justify the reservations and to justify why they cannot comply with their treaty obligations and why they cannot reform the laws that discriminate against women. So if you see here, US joins Iran, Sudan, and Somalia. in not ratifying CEDAW. Really disgraceful. And most of the OIC countries, actually 29, have ratified without reservations. Most of them are African and Central Asian countries, so Kazakhstan, Uzbekistan, and all that. 28 ratified with reservations. All the Middle East, North African countries, and countries like Malaysia, have ratified with reservations. And the most reserved article is really Article 16 on marriage and family relations. All those 28 countries reserve the whole of part of Article 16. And quickly, let me just say right to enter into marriage, responsibilities during marriage and at its dissolution, rights over children, financial rights, all those key rights in marriage and divorce that Muslim countries have reserved. And I just want to take you through what are the arguments that they have used. Yeah. So key argument is that Sharia is divine law. It's God's law, so therefore it cannot be changed. That they cannot lift the reservations because the articles in CEDAW are incompatible with Islam. This is the language that governments use. Yeah. Conflict with provisions of Sharia. It's sacrosanct. Sharia is sacrosanct. The nature of religious belief is sacrosanct and will not be called into question. That's Egypt. Sharia law is a settled matter. It's settled. It's revealed from God. You cannot question it. The second, group of arguments that they've used is that, of course, there are different treatments. I mean, those laws discriminate against women. But the governments then present to the CEDAW committee that those different treatments of women do not constitute discrimination. Yeah? And they use, look at the language they use is reciprocal obligations, complementary roles. The danger we talked yesterday in the group about the constitution in Tunisia, where there was an attempt to look at men and women as complementary. It's a very dangerous word in this context. Equivalence of rights and responsibilities, just balance to ensure family harmony. So all this differential treatment do not constitute discrimination, the government says. So for example, and it likes to give this example, where a man gets double the share of inheritance, is because he has that privilege, that right, because he has extra responsibilities that women do not have to support the family. But of course, never mind if the man doesn't support the family, he still doesn't lose his double share of inheritance. So the third cluster of arguments that the governments use is culture, customs, traditions prevent full implementation. So this is where governments say, we are ready for change, but the people are not ready for change. So it has to be slowly, carefully. So change is difficult. We really want to do it, so you have to understand. So you look at Maldives' language. We want to amend those discriminatory laws, but impeded by social, cultural, and political situation and current interpretation of Sharia. This is on the issue of polygamy. So the question we raise is who is not ready for change? Who in the community is not ready for change? There are women's groups like us that are pushing for change, but of course the government doesn't choose to listen to our voice, but instead choose to listen to the voice of the patriarchs. Another cluster of arguments, and this is used by minority Muslim countries, countries that have minority Muslim population. Again, the government is ready for change, but the community is not ready, and the argument they use is their respect for cultural diversity, religious diversity, and the rights of minorities to their own cultures and customs. So India says we can't change without community initiative and consent. Singapore says to preserve the harmony of multiracial Singapore, we cannot push to end discrimination against Muslim women under the Islamic family law. Sri Lanka says no change because of religious sensitivities. We need the approval of the community. Again, we raise the issue, whose voice in the community? Since when governments want to go to war or buy weapons or do what, they will just do it without any consent of the community. But why is it that when it comes to women's rights, you have to wait, you want to be so democratic and wait for consent? So what we did then and this is available on the Musawa website, this is a publication. What we did then was to critique the language and to offer what we call the Musawa framework for action, which we developed at the launch for the launch of Musawa in 2009, which basically what it does is it integrates in the push for reform of discriminatory laws and the use of Islam to discriminate. We push what we call the holistic framework that grounds the Islamic arguments for change, and we take the position that change is possible in Islam, grounds the Islamic arguments in universal human rights principles, in constitutional guarantees of equality, and many Muslim countries do have constitutions that guarantee equality, and in the lived realities of women and men. So we look at socioeconomic data to also support the reform. So, and we provide, in terms of the Islamic arguments, the historical jurisprudential arguments to say that change is possible. So what we did was, the why is change necessary, why is change possible, why is equality necessary, why is equality possible. And we look at, the disconnect. What we do in terms of the lived realities research is to really look at the disconnect between the realities of women and men's lives today, Muslim families today, with a legal framework that basically, a framework that discriminates against women. Yeah, and that we argue that the legal framework in Islam today, many Muslim countries today that use Islam as a source of law and public policy no longer responds to the needs, experiences, and values of the realities of lives today. And then we developed, the Musawa framework developed certain basic concepts in Islamic legal theory, the distinction between what is revelation, Sharia, and what is jurisprudence, which is human-made and therefore open to change. The difference between laws that govern your relationship with God, ibadah, and laws that govern relationship with humans, which is family law, is mu'amala, is open to change. The whole heritage of diversity in Islam. So basically, there are so many conceptual tools and jurisprudential tools and concepts in the tradition. You don't even have to produce the new ones. The concepts exist within the tradition for change and for reform to take place. And to really make the point that the CEDAW committee, the UN, the international community really has to begin to challenge governments and they use this blanket assertion that this is Sharia law, this is God's law, it cannot be changed. Yeah? This is human-made law based on revelation, but the construction of that law, the product of the engagement with revelation is human-made law, it's not divine law, and therefore open to change. So let me just give you some examples. This favorite argument of the state that, this different treatment of men and women is reciprocity, is equivalence of rights. It is not discrimination. And again, how the economy with language, they never tell the CEDAW committee, and this is part of the problem and challenge that we face too, because the CEDAW committee members are not experts on Islamic law and are reluctant, especially both the Muslim and non-Muslim members of the CEDAW committee are really very reluctant to take on the governments in a strong way. There are, of course, individual exceptions. And so we felt it was important that we really expose to them, I don't want to use educate, it sounds patronizing, but really expose to them and raise their attention to how best they can challenge the governments that appear before them. The governments don't say, when they talk about reciprocity and equivalence of rights and all that, they don't say actually that underneath that differential treatment is inequality. Yeah, the husbands provide maintenance, in return the wives are supposed to obey the husbands. And in divorce, if the wife claims for backdated maintenance, if the husband accuses the wife that she has failed to obey him, he is not obliged to give her maintenance. Yeah, so that whole obedience is linked. The whole maintenance issue as duty to maintain is actually linked to obedience, and that is basic discrimination and equality. So they allege that men's responsibilities lead to privileges and rights. They have those privileges because of their responsibility. And the privileges they get is double share of inheritance, right to divorce at will, right to demand arguments. And we argue that this position really does not correspond with today's reality. Fewer men are sole providers, protectors of the families. More and more women are working and providers, and sometimes even sole providers and protectors. And today most women are co-providers. And again, that these rights and privileges, they are no longer lived in practice. Men fail to provide, they do not get punished or lose their privileges. Women who do provide still have to obey their husbands and do not get a fair share of inheritance. And then we dealt with some of the major issues that the CEDAW committee often deal with Muslim governments. The areas of discrimination, polygamy, child marriage, forced marriage, financial rights of women, obedience, inheritance. So I'll just give you an example in terms of polygamy, where we looked at the state party's arguments, that this is a right in Islam, cannot be questioned. This is a right in Islam, but there are conditions, so it's really not that bad. And some of the stupid arguments that they use, men have stronger desires, prevent, adultery, women are infertile. These are all excuses that the governments use to justify why polygamy is allowed in Islam. And then what we did was we came up with the arguments, using the Musawwah framework. What are the arguments within the Islamic sources to challenge that interpretation of divine right to polygamy? We look at the verses in the Quran, we look at the traditions of the Prophet, we looked at the marriage contract. I was telling some friends, one of our scholars in our group who did research in the archives in Egypt found a papyrus record, a papyrus marriage contract, where, and this is the 8th century, 9th century, where the husband delegated his right to divorce his wife, to divorce, should he take his second wife, his first wife has the right to divorce the second wife. So he gave that right for him to divorce the wife to the first wife, to divorce the second wife, should he take a second wife. So it's amazing that in the early years, we had all this tradition. For example, throughout the Ottoman period, for hundreds of years, polygamy was the most frequently written down condition that a woman has a right to divorce her husband should he take a second wife. So the tradition of marriage contract in Islam dates over 1,000 years, where women could write conditions to protect their rights. But again, like today, like so much of that is forgotten. And then we developed the arguments at the international human rights level in terms of looking at treaties, various treaties. And we actually worked with the Virginia Law School legal clinic to develop this, and they looked at all the human rights treaties on issues of male authority and how, and guarantees of equality and non-discrimination to support our work. We look at constitutional guarantees. In many Muslim countries, there's equality before the law, and in some countries, no discrimination on the basis of gender. And then, of course, we look at the lived realities, whatever research that exists in terms of the impact of early marriage, child marriage, polygamy, here in this case, in terms of the impact of polygamy, the detrimental impact of polygamy on women and children. And then the last bit, what we did was we provided examples of rights-based laws in other Muslim contexts to show the CEDAW committee, again, and to show the governments, look, if you say that this is divine law, why are there differences, in so many Muslim countries? If it's divine law, it's all the same. It's not the same, yeah, it's man-made law. So we look at the positive laws in other Muslim countries. And so this provides easy reference to the CEDAW committee in terms of doing their work and the engagement in government. So in terms of the follow-up that we've done, is we do trainings on this to many activists who are writing shadow reports to the CEDAW committee. We went to Geneva and also did a training for the Office of the High Commissioner of Human Rights for the CEDAW committee members. We brought our scholars in to basically give them a whole day session on understanding Islam from a rights perspective. We're now submitting what we call thematic report on Article 16. So when key Muslim countries submit their reports to the government, we basically go through the report and provide the critique and the arguments and questions to the CEDAW committee to challenge, to raise with the governments. So this is ongoing work for us, and the next step that we are planning to do is to really, the CEDAW committee, after the state parties submit their report to the CEDAW committee, they go back and respond with a list of questions asking for further clarifications. So we're now getting into that process where we want to influence the list of questions that the CEDAW committee raised to the governments in order, to get further information from the government. So this is really ongoing work. Change takes forever, but I think what is important is to really raise the level of awareness and confidence in by NGOs, by the CEDAW committee, to really start to challenge governments and their use of religion to justify discrimination against women. Thank you.
And now our last panelist, founder of the Women's Institute for Legal Leadership Development.
Thank you. Good morning. I want to be a little colorful because I knew it was the morning on a Saturday. So the question that was posed was around, have human rights created the political space for reform? And, that's always debatable, right, depending on who you ask. And there has been actually more doubt coming from the West Coast law schools than the East Coast, and I think that we have to acknowledge. So I'm going to just skip that part and really go to answering how human rights have been used to create the political space, and using San Francisco as an example. So I want to look at the definition of human rights, right? The definition that makes sense to people, right? Because if you have to look at human rights from the context of it being relevant to the people whose lives you're going to change. So the basic definition is constructing conditions in society for people to be fully human. And the picture next to it does not look like it's the desired outcome for that comment or the thinking around it. So part of constructing conditions in society for people to be fully human means that those whose humanity is threatened must decide what it means to be fully human. Something I think we overlook in most cases, right? That also means that women, in this case talking about gender equality, engage in the decision-making process. And I want you to look at the definition that CEDAW provides around gender-based discrimination. And of course, the conversation gets much more simpler when we talk about the implementation of CEDAW in San Francisco, and also it complicates, international human rights standards. So if you look at this particular definition, right, the challenging question for us when we started Wild for Human Rights and wanted to work within the US borders on human rights, the question was, don't we have it already, right? And don't we have extraordinary laws in the books? So why do you want to bring in human rights standards into the country when it's really not, used and constantly challenged? So we have to really show the added value of human rights, right? So look at the language, right? If you look at any distinction, exclusion, or restriction based on the basis of sex, right? It includes a lot, right? It includes more than what our books say, right? What our domestic law says.
Then if you look at equality of men and women, right? On the basis of equality of men and women, this is questionable because in all societies, men in certain communities may not be treated really well. So the question arises from the African American women in the United States. Do we want to be equal to the black men who are treated bad? Is this what we're asking? It was asked by the Tamil women of Sri Lanka, right? And the Palestinian women. So, and I think the question is, and also you have to think about when it was written, right? And at that moment in time, it was about equality between men and women. But you have to then look at the relevance of that language to see, is this what we are really asking, right? So this is where, we were really, as when we brought in more women of color into the dialogue around, human rights, how do you construct conditions in society for women to be human in San Francisco? These are some of the things that challenged us and also that we had to really define, right? And look at the last part of it, right? The fundamental freedoms in political, economic, social, cultural, civil, or any other field. Any other field includes private and public. So this is the added value of using human rights for us, to really look at discrimination within the United States. And earlier it was talked about that the United States is one of the very few countries that has not ratified CEDAW. So when we started this work, I want to give you a little bit background on the model for human rights. We started it in 1996, right after Beijing, 1995. That's the decision was made on the Great Wall amongst a few women from the US. One of them a Stanford alumni, Patty Chan, to start the fight for human rights. And the aim was to really look at, can we do human rights work within the US borders to improve the quality of life of women? Right? So part of that was also to show that human rights can be relevant in the United States, but also because we had to really literally sell that idea, right, to women, not to men, to women, whether human rights would work for us, right? Using a treaty that the US had not ratified. So it's a fine line between being brave and stupid, and we cross it all the time. Because, in one sense, when we went to Washington, DC, the folks in DC who are really looking at national ratification said, are you out of your mind? This is going to really undermine the work at the national level, right? But we couldn't wait until the national ratification to prove that human rights make sense to them, right? So we had to, as Wild for Human Rights, we had to really figure out what's the entry point, right? How do we not step on the toes of the national, women's human rights movement, right? At the same time, make it practical, right? So that dance went on for a while. And so I want to talk about when we decided to work on CEDAW in San Francisco, it was a test. It was a test to see, can human rights be relevant at the local level in the United States, right? And you have to think about, when we talk about the United States, there were a couple of things that went against us. First of all, we were talking human rights, and it was always considered an international thing. It's what you do to save other countries, okay? Second, we were talking to women and we were looking at the definition of human rights, constructing conditions in society for people to live, which meant that we were bringing in immigrant women, indigenous women, women of color, poor women to the table beyond the standard folks, right, and the educated women, which meant that they were already cynical of human rights because it did work in their countries, but in the United States, it was looked upon as, that's what Amnesty International does. Now, who is a member of Amnesty International, including myself, right? Educated, middle class to upper class, liberal people. Like, they don't know what's happening, and why did Amnesty International and Human Rights Watch at that time really work on the United States? So that was a question we were challenged, right, to answer. So I think it's with that we have to really figure out whether we were doing the right thing and whether this was the best strategy for us, right? And I put out 3 points here. The key elements are really at any level, national, international, or domestic, right? There are things to consider. And once you have your heart set on doing something, rest is strategy, right? It's really doing things at the right time with the right people. So we had to really examine the social and political climate. Now, it was 1995, right? There's a surge of women from the US were talking about women's rights being human rights. At least the rhetoric was there, right? It was excited because we had connected to the larger global movement, right? It was Hillary Clinton who made a speech, right, in 1995. Everyone was trying to figure out what to do about Beijing, right? And how do we work now, and how do we keep connected to our sisters outside? Think about California. We had passed Proposition 187. Okay, now I'm dating myself. Okay. Then we also had Proposition 209, right? Anti-affirmative action proposition. So it had just passed, and women in San Francisco, right, and actually statewide, were questioning now what do we do? And this is going to come down, and how are we going to address some of it? So I think we had an opportunity then to look at human rights, because the domestic system had failed, right? And it also brought together 2 different types of women. Proposition 187, anti-immigration proposition, brought in the immigrant community, right? Proposition 209 was middle-class women, right? Professionals who were questioning that space. Now in San Francisco at that time, we had the largest amount of women on the board of supervisors, right? It was an extraordinary time in San Francisco, and the president of the board of supervisors was a woman, Barbara Cox. So our time in our political climate was pretty good, right? Now leadership, institutional and individual. Now Wildfire Human Rights had just gotten started. My work beyond that, before that, was with Amnesty International, an organization that was looked upon by people of color, like, what are you doing, right? And I had done domestic work. I had worked in the battered women's movement in San Francisco, but it wasn't enough to really kind of position my credibility and the organizations. So we brought in 2 key partners, Amnesty International, because globally and nationally, Amnesty International is extraordinarily respected. I had done my women's human rights work with Amnesty International, and he had access nationally in the event we were challenged out of Washington, D.C. if we were going complete crazy in San Francisco, which from time to time is questioned, right? And the second group was now called the California Women's Foundation, and before it was Women's Foundation, right? Based in San Francisco, and the president of the Women's Foundation was at that time also the president of the Commission on the Status of Women, right? So it was and they were funding women's organizations, which meant that if there was a letter that went on their letterhead to the women's organizations in California saying, come for a training on women's human rights, they were going to come, right? So that's how we actually built in the folks to get in there. And I want to actually acknowledge Amy Ackerman, who is here, who was actually the one who drafted the language on the CEDAW ordinance from the city attorney's office in San Francisco. Yes. And the third one was community engagement. And one of the things we had to do is to keep human rights relevant to the people in San Francisco, to the women, which meant that we asked a question at every meeting, which was once a month, right? What do we need in order to make the best decisions, right? What does the group need, right? And are we walking on top, right? Does the process reflect the outcomes we are seeking? Is the decision we are going to make improve the quality of life of women? Right? So we asked that like at every meeting there were different people. So this was like a way in which that for 2 years we were able to keep the momentum going. So just to briefly inform, the first one we just covered. So San Francisco became the first city in the U.S. to pass CEDAW at the local level, right? And the city, had some key elements that they pushed on. There was a task force to oversee the implementation. There was $200,000 that was questioned to start the work, right? And that it required a kind of the ordinance asked for gender analysis in allocations of funds, service delivery, and employment. Right? And it's very practical, right? And the third was during 1998 to 2006. There was a fully functioning task force. There were 6 departments that went through the gender analysis, and there was a staff, who was actually working, at least 1.5 staff people doing the work at the Department on the Status of Women. Right now, I think Amy can speak more to it. It has shifted. So the original ordinance has been reworked. So it went from a task force to having a committee for CEDAW, and it moved from really doing the work within the city of San Francisco, the city departments of San Francisco, to the private sector. And I think that's extraordinary, because if you think about if CEDAW is applied to the private sector, it's not as much as we would like. So there's the gender equity principles that the Department on the Status of Women developed, and they're working with a couple of corporations in the United States. But I want to talk to you about some of the key successes that came up that will show you what the gender analysis within a human rights framework did. So 2 departments I would like to take. Department of Public Works, right? Those are the guys who put street lights, right? Predominantly men, right? So this was one thing that we sold CEDAW on to the city. Street lights are put, there's no law about where the street lights go, right? What the distance between street lights are. You know how women are in the dark compared to men, right? We are frightened of the dark, we walk faster, we are conscious, we want light. So when we asked the Department of Department of Public Works, they said, no, there's no gender issue here. We are about, we're about providing all citizens in San Francisco, right? Everything that they need when it comes to, public works. So when we talked about street lights, it was predominantly men were putting street lights, but based on where they thought they ought to go, right? After they did the gender analysis, right, they started putting street lights much closer in San Francisco. Right? The current mayor, Mayor Ed Lee, was the head of the Department of Public Works at that time. Was very excited about the change that they had. And the other one is around juvenile probation. What happened with juvenile probation was there were 2 women actually who were heading the department. They were concerned that if they really talked about girls in juvenile probation, they would be marginalized because there were two women in leadership, 2 women of color, right? They knew that there was a problem. They didn't know how to tackle it. They didn't have the way in which they could say, because yes, there are girls, but how could you say girls need different types of programming with a majority of them are boys, right? And so if you're looking at equality, 75% are boys and 25% are girls, right? The budget is split that way, which means that there's no money to improve and provide new programming for the girls. So the gender analysis actually helped them make a case that the girls needed different programs than the boys. If you're thinking about an equitable system, right, they had to have exquisitely kind of developed programs and actually have a staff person. And they got the money for a staff person. So, there are others, but these are the 2 things that shows service delivery and in direct and indirect ways in which the gender analysis helped. Now, there were departmental-wide changes. There was the family, work-life balance survey that they did, the Commission Department on the Status of Women did, and and there were changes for employees. Now, where we went wrong, all right, is around the emphasis, because it was a department on the status of women, and this is where we were able to, with the task force, make the most of changes, was around employment, right? Service delivery, so employment, we were able to improve the quality of life of the women in the city, more than actually impact the services and the budget, because resource allocation was one of it, right? And there were women, for example, the first woman commissioner was appointed to the airport commission. So based on numbers, women were doing fine in San Francisco, right? If you look at actually the appointments that San Francisco City did. However, right, when you look at where the women were, they were in just traditional commissions, aging, youth, commission on the status of women, not, the commissions that were not generating income, right? So the first woman was appointed to airport, right? And we really looked at where women would go when it talks about police, commission, right, and fire and port authority. So statewide also meant that there were other cities who were trying to do this work across the country. At the national level, now finally we were able to make a case that human rights are relevant in the United States, and actually Wild for Human Rights at that time became the poster child of the success story of human rights. Right? We were kind of picked up by all the foundations, and during that time actually there were two things that were significant that that the local implementation contributed to. One is starting a domestic human rights, U.S. human rights fund, right? We were able to make a case in saying like, you got to put money for U.S. human rights work. And the second was that there was a network that got started with by Wild for Human Rights called the U.S. Human Rights Network. Now we have over 400 members in that, in that network. So internationally, where this work came into play was that, yesterday there was a question. The work is normally done at the national level. Yeah? Women's human rights work is at the national level. CEDAW is work on a national level, right? So local implementation and domestic work, and where you can see the change, is much harder because it takes a while to come down, right? The pipeline. So at the national level, we were able to really showcase that regardless of what happens at the national level, right, organizations at local levels can use CEDAW, especially if you're ratified it. It makes a big difference. So that's kind of the contribution of the local work had in San Francisco. Japan especially actually is looking at local implementation because they have to look at, and looking at San Francisco because they have to look at how to impact, companies and how to impact the workforce where women are completely discriminated against at all levels. The challenges, the lack of resources, that goes without saying, on two accounts. One, even for the Department on the Status of Women, it's been really hard to, it's a fight every year, and I think Amy can speak to that, as to what the department has to go through to justify their work, right? But externally, what happens is that when you mobilize a group of people, and when you do the work, in this case, what Wild did and many other organizations have done around the country, once you pass the ordinance, nobody funds you to actually implement it or to monitor the work. So I think it's really critical to figure out to keep that momentum going because somebody wants another win, right? So the implementation really takes a back seat, and therefore it was, and this was where Wild for Human Rights failed, was that to keep the momentum going, to implement, to keep at it, and to get people organized, to monitor, was much harder. Accountability and transparency. Now remember that even San Francisco, it's a city government. You have to have folks who are holding the city accountable. And the initial accountability mechanism that we had put in place failed. It failed because of the way things were at that time. So it is much harder. So when the Department on the Status of Women changed the way they wanted to implement CEDAW, there was no transparency, there was no accountability, because we did not have the number of women who originally were engaged in kind of implementing, like passing CEDAW at the table, right? And I think it goes for at the national level as well. But even at a local level, it's much harder, even when it's your friends that you're working with, right? Limited understanding of human rights. Now, this is mainly from a US context, that you're constantly translating human rights to a new group of people, to new staff, at city levels, right? And then also making a case that human rights does work. And measuring human rights. So actually, in this picture is current mayor Italy, right, who was an enormous fan of CEDAW and actually worked, and when we did trainings, he was one of the few people who came and spoke at the training. So I think it's something new. And he recently actually spoke about CEDAW implementation when Aung San Suu Kyi was in town last week. So the last one, measuring human rights, is really key. So what happens is we put our emphasis on passing the legislation, right? All your eggs are in one basket, because that's what we push on, right? So we do not think about actually the outcomes, right? We don't see when CEDAW is passed, what are we really looking as change? What are our benchmarks? We didn't do that. And I think I can safely say that most don't, because this was a discussion 2 years ago, right, around those who came together on CEDAW, right? So measuring human rights is not a typical way to measure like development, right? It's not, so monitoring and evaluation is big, right? Every funder wants it, World Bank has an entire department, and they're doing brilliant work, right? As far as development work around monitoring and evaluation. Human rights monitoring and evaluation is different, and I think that has to be really kind of kept in mind. And I think I want to touch on the second one, right? We talk about respect, protect, fulfill. So that is actually a hierarchy in human rights, although we never call it that, right? We look at violations first. Then we look at protect, because it's a second party, and we look at fulfill if we have the time. Okay? So we have to really think about, if you're serious about implementing human rights, you really need to change it around, right? What is the ideal world? Because if you're looking at not reacting, but proactively changing the way women's lives ought to be, then you have to look at what should the world look like for women? What should San Francisco be like for women? And how, and when do we want that to happen? And how do we then measure? And integrating intersectionality is really key, because we are not just one identity, right? And we have to look at what happens to different types of women. And understanding the inextricable link between domestic and foreign policy. If you're looking at human rights have no borders, okay? So if we are to be credible as US people in the international arena, then we have to look at what our foreign policy does to our sisters outside. Doesn't mean that you have to run around and apologize, but you have to know it. And you have to support each other's work at the table, because we were really supported by those, not from within the US borders, but from outside when we started doing CEDAW work. Practice new ways of measuring rights. And I'm going to end with the last slide in saying that, you take all your mistakes and then you figure out how to make it right? So my current work is really around developing an equity index, right? Which is a human rights tool that's designed to help and achieve the desired quality of life, looking at outcomes, right? And really looking at then how do you have benchmarks and proactively use CEDAW to address discrimination. Thank you.
So, question? Yes.
How does the two mics set up? You don't mind using the mic, so it's easier for anyone to hear.
see that the fact that the United States has not passed CEDAW makes it possible for some of the other nations that have not passed CEDAW to justify it, since we are supposed to be better at human rights.
Nancy, in the room, who is doing a lot of work around international ratification. Do you want to cover it?
No, I will let you.
Okay. Yes, I know. I think it's hard as activists to be in the international arena when your country has not ratified. We are making horrendous policy, at the international level, pretending that we are ahead of the game. So it's difficult. I think on the other hand, we are proving something as well, because women's human rights has to go on, and governments are not the only ones who are responsible. We have to take charge, right? And we have to figure out creative ways to do the work in spite of our governments. So I think, that's important.
I'm going to add one sentence. I loved your answer. There is a very strong coalition that continues to lead the campaign for ratification, framed in a multitude of different ways for different audiences, but holding fast to the principles. We are hopeful that there may be yet another hearing with Senator Kerry in the Melinda session to lay down markers on ratification. There are some in the Senate that continuously have questions with international treaties in general, and we are, with this administration, advancing the concept of ratification. I'd like to know from those of you who are working around the world whether or not it makes any difference at this point that the U.S. ratified.
I was hoping you'd ask that question. That's an elephant. Yes.
My work around the world is about using the CEDAW as a blueprint in law reform and in litigation. And the CEDAW is one of the most powerful tools for women's movements around the world in reforming their laws, in bolstering their advocacy efforts to urge the state to comply with the laws that are on the statute book, as well as creating social movements that are bolstered by the CEDAW. At the moment, the U.S., as you said, uses model authority because of the fact that it has not ratified the CEDAW. But it also creates a dynamic that is very interesting because of the fact that it gives the women's movement, the international global women's movement, a sense that they don't have to be bound necessarily by the U.S. policies because of the fact that they can hold themselves to a higher global standard of UN human rights standards. And I think that, that impoverishes the U.S. commitments to global standards, but it also raises the standard all around. It creates this fact that, these UN human rights standards are not U.S. standards. They are global, they are universal, and therefore have a commonality of application irrespective of whether or not the U.S. has ratified them.
In my work, I'm working on women's rights in the Middle East and North Africa. I would also, to add to what Nina said, it also undermines for U.S. foreign policy efforts. It sort of underlines our lack of having ratified CEDAW, underlines how the United States applies international human rights standards only when it seeks to. So it underlines for people who don't want to support CEDAW to talk about American double standards, like democracy applies, but only if we get the result we want. Women's rights, well, we want other people to apply it, then it's not going to apply to us. So
for American foreign policy makers in the United States.
I'm Ann Lehman. I'm Policy Director of the Department of Status of Women. And I wanted to update folks a little bit on what we're doing now implementing CEDAW. I've been working on it since 1998 when Krishante got it passed. And a couple of things. One of the things that was disappointing is after we developed this task force and these very detailed gender analysis guidelines, we had really hoped that folks from around the world would join with us in further evolving them, and that hasn't quite happened. When we did them initially, they're 30 pages long. You can imagine that the departments that we were analyzing were a little overwhelmed by the amount of questions that we were asking. One of the things we are doing right now is taking those initial gender analysis guidelines and trying to really refine them down to a set of maybe 10 to 15 questions. And part of that is being modeled on work that we've done since then. Some of the frustrations we had in working with government, we decided, and part of the statute, part of the brilliance that Amy and Krishante did was put into the ordinance, the CEDAW ordinance for San Francisco, that these principles should be taken to the private sector. So about 5 or 6 years ago, we did that. We started out looking at what was already being done around the world, got into the whole social responsibility movement, the Global Compact at the UN, and basically developed a set of principles called the gender equality principles that are for the private sector. Really, how do you create gender equality in the workplace? And we had joined with us groups like Google and Symantec and McKesson and Deloitte and the San Francisco Community Foundation and a number of other groups to help us really refine what these principles would look like. And because we really didn't want this to stay at the global level, we developed a set of, again, way too many, 600 indicators, benchmarks, for what that would look like. After launching about 1.5 years ago, the company said, "Are you out of your mind, 600?" So we got it down to 100. We're being told even that's too much. We developed a quiz with only 7 questions. But we now have a whole website that anybody can use. It's free. We are government. We get things away for free. That anyone can go on, any company can go on, any business can go on. It's called genderprinciples.org. I have postcards around here about that. And we're basically now trying, and we do roundtables where we bring together people focused on one of these issues, one of these 7 principal issues each time. We bring in experts, we network, we share best practices. And we're using that as a model for how we now want to go back and revise what we did for government. I have some materials here too if people want to hear a little more detail about that.
What's that good award?
We won a Work Life Award from an international symposium. This is actually kind of interesting. In Italy, women were not having enough kids. And so the Catholic Church really, and the Catholic universities there decided they needed to do some kind of work-life balance initiative to get women who were working to have more kids. And so they started this worldwide initiative, and surprise, surprise, this year they gave us an award for our Gender Equality Principles Initiative. They obviously weren't looking very carefully at some of the indicators that we had, or they would never have done that. But we were able to highlight some of our work.
Other questions?
I'll ask it seems to be something of a perennial question, but I'll ask it at this panel, and that's the sort of mainstreaming question. Sort of one of the things about the focus on CEDAW is that the sort of the danger is that it's those women doing their thing again, right? So I wonder if you could comment a little bit about, especially doing the anti-discrimination work, whether you've been able to take it beyond CEDAW, because every human rights treaty has anti-discrimination provisions, right? And so the question, why strategically focus CEDAW rather than somewhere else? And then is it possible to build on the work in CEDAW and expand that out so that you don't run the risk of marginalizing? Thanks.
Well, I'll start by answering just from a perspective in terms of using the treaty monitoring bodies of the UN, is that we do bring claims before all of them. So we've done a lot before the committee that oversees the Covenant on Civil and Political Rights,
And so we do both. In fact, we went to the other committees first. So, for example, we brought an abortion case to the UN Human Rights Committee that oversees the Civil and Political Rights Conventions before we brought one to the CEDAW committee. And the framing there wasn't discrimination, but it was that it was the denial of an abortion to a woman who had MS of the fetus group. And therapeutic abortion is an exception to the group's abortion laws. But we also brought it as a cruel and degrading treatment. So the committee actually found that regardless of whether it was legal or not, it was cruel and degrading treatment to force this woman to abort pregnancy. Later, and this case also just came down to the CEDAW committee, we brought another case against Peru with a young woman who had been sexually abused for years. And she, at 14, tried to commit suicide when she was pregnant. And she jumped off a roof in the village and broke her back. And when she got to the hospital, they knew that they had to do emergency surgery to try to maintain her mobility. They found out she was pregnant. And they refused to do the surgery because it would involve termination of the fetus. And so she miscarried several months later. They did the surgery then. She was quadriplegic. And we took that case to the CEDAW committee. And they found that it was a violation of the convention, and among other things, you have to have an exception in cases of rape, not exception in the group. So we try to build the links between the different treaty monitoring bodies, so we won't just be in CEDAW.
Maybe this is a follow-up question for Shanti, but as you were talking, I couldn't help thinking that a lot of what you accomplished through CEDAW, other localities could accomplish through standard anti-discrimination ordinances and commissions. I see Amy shaking her head. But bringing a gender lens to city work is not something that only CEDAW can serve as leverage for. I guess that's my point. So maybe you could say a little bit about what you think the distinctive contributions of the human rights lens. I understand that symbolically it makes, it gets you to some places to say, we're the first, we've adopted this universal standard, et cetera, et cetera. But as a practical matter, couldn't your work be replicated by other localities that don't adopt CEDAW?
So actually, I will pose that question and ask the first question around, where else we could go using human rights and beyond CEDAW. From the US, actually, we have really looked at CERD, the Convention on Elimination of Racial Discrimination, especially with the World Conference in 2001 that happened to bring in the issues around gender, and that's when Kimberly Crenshaw really wrote the piece around intersectionality. And of course, then there was September 11, 2001, so kind of all the work that went into looking at CERD and CEDAW together from the local groups kind of vanished, right? But nevertheless, we have done the reports around women of color in the US, the treaty body. We have also looked at the ICCPR, International Colonization and Political Rights, treaty body, and CAT, Convention Against Torture, looking at women of color in California prisons. So there has been spaces, and I think that's continuing, that's beyond CEDAW. But what's important about CEDAW is if you're trying to bring a group of people together to look at the relevance of human rights, right? And in this case, women, then CEDAW is your entry point. And that's not where you ought to stop. And I think if you're looking at gender is not about women, it's about how women are treated, women and men are treated in society. So we have to make use of that definition and enter all aspects. So I'm going to go to your question now, and I want to share it with Amy because Amy might be able to say more. I think, to me, human rights standards are way beyond. Even if you look at the definition, it allows us to do more things around just discrimination. Right? And when you look at actually beyond San Francisco, those who tried to do the work brought in CERD and CEDAW together, and New York is a great example of that. So from an organizing standpoint, in order to pass it, it's not just about doing it the first time. It was about really expanding the discourse and the definition and doing preventative work from an organizer standpoint and an advocacy standpoint. And you can.
I think I asked that question. I was a deputy city attorney, and I drafted a lot of legislation. And these fabulous women came in, getting fired up from Beijing, and I said, but I just read the principles of CEDAW, and we have all those rights already in the U.S. So what is it that you're actually asking me to draft? I said, I can't. We got federal preemption problems here. I can't say that in San Francisco. So what are we doing here? So we had a lot of meetings about that. I got very educated because I think so we had to say, and what does that mean in a city? Okay, we don't have control over banks. Not that San Francisco hasn't tried. Multiple times. Well, we try to have control over everything, which makes it so much fun. But, so we really got down into, and I think the best way I could is I got kind of trained into looking at a human rights perspective, and that there is a difference between not discriminating and equality. And I don't necessarily think you have to do it through CEDAW, but what we're talking about, and this was also right after Prop 209 passed, and the city was really scrambling because the city had minority women-owned business enterprise preferences, and San Francisco did manage to litigate Prop 209 for about 10 years before they managed to raise every possible legal argument to keep their laws on the book until they did finally lose. But that's okay because we're still working. So it was really looking at three key components within city government is employment practices, and looking at not just are you discriminating, but how do you make it equal. And one of the most interesting examples came out of juvenile probation, where they had focus groups between male employees and female employees. And lo and behold, both men and women said, we would really like more safety training from juvenile delinquents when we meet with them. So, and what was interesting too is there happened to be quite a few male single parents. And when they staffed the juvenile hall facility, these guys are working nights and stuff, and they were really having trouble finding childcare for nighttime. So it actually looked at barriers that go beyond not discriminating. And I think we also, the other factors for provision of services, direct and indirect, how our budgets allocating the resources. I think one thing we've learned is that's a really hard question to answer. But the city has a children's fund where a percentage of property taxes goes into children's services now. And there's the second go round, and we learned by doing, is a much tighter charter amendment, and they do evaluation, and they look specifically at boys and girls and how they're served, the numbers and stuff. So you've seen it get integrated into aspects of the department. And what's our third point? Delivery of services and budgeting. Where's budgeting going? And so the streetlight example is a good one. Are you considering things not really discrimination where you place, but if it affects quality, you can look at it for where you place transit stops. Are they near where women tend to frequent? So I think maybe it doesn't have to be done through CEDAW, but I think there's a difference between not discriminating and looking to build equality. And Prashanti may consider some fails, but I am a little more optimistic because I have the experience of walking in the hall of the City Hall, and a couple supervisors were running to a budget meeting, and this was in bad financial times, and I got to do budget cuts. And one said, yeah, remember CEDAW. Remember CEDAW. So there you go.
I think just add, in many countries that have ratified CEDAW, the Constitution is not implemented actually, because the Constitution says you have to adopt it at the local level, at the national level, into a national law before the government is then tied to it. And many countries just ratify but don't localize the law. And I think what you're doing is extremely important and can be promoted at the local, meaning city level, provincial levels. Because for example in Malaysia we have states that are under opposition rule. I mean the opposition parties at the federal level have won elections at the state level. And many women's groups, many activists are involved in the opposition parties and have actually tried to introduce, gender equality measures. So I think this is something that actually can be replicated and adapted, in other countries where it would be, you can pass an ordinance and it would be easier to push it at that local level.
I was really interested in hearing more from Zaina about some of the challenges that she's experienced doing the work that she's done in Malaysia and now internationally. The first time I met Zaina, I was a fellow for the Asian Society, and we were in Malaysia. And the first night we heard from the Prime Minister of Malaysia, and he painted this very rosy picture about diversity in Malaysia. And then the next day we heard from Zaina, and she told us it was all BS, and this is what was really happening. So I know she has this incredible ability to speak truth to power, but I imagine trying to challenge the patriarchy in any religious hierarchy can be very dangerous even. So I wanted to hear more about that.
Well, I've been doing this work for over 20 years now. You're actually energized by it because there's so much opposition to your work. and that keeps you going. Yeah, it is, it's not, you don't make yourself popular. You get all kinds of attacks, Friday sermons, and now with social media, it's like endless attacks. And I guess basically it's really a whole issue of authority. It's like, what right? They just cannot figure out the gall that you as a woman who's not covered up, who doesn't speak Arabic, who didn't go to Al-Azhar, what gall do you have, what right do you have to speak about Islam? So basically what we've really done, and that was the intent, really is to create a culture of public debate on Islam and to expose the public to the fact that there are diverse views in Islam and that there can be justice, there can be equality, and that there can be reform in Islam, and to really get that out in the public space. And we knew that we were not going to, to get the traditional platforms to speak on religion. So it was our deliberate strategy from the start to create our own platforms, to create alternative platforms, and that was when we used, the idea of how do 8 women who got together, try, to assert our voice as a voice of authority on Islamic matters, and we use the media as that first entry tool, letters to the editor, in fact, letters to the editor in the newspapers to challenge statements by ministers, by religious authorities, court decisions, policies, anything that uses Islam to justify discrimination against women. And of course, all kinds of accusations that the work that we do is against Islam, is against God. It's endless, the criticisms. Currently, we have a case going through the courts. I mean, it's amazing how they keep appealing. The government, the Home Ministry banned one of our books that looked at the impact of political Islam on the women's rights. We had a conference that brought together women's groups in Southeast Asia and the Middle East to look at this. And we came out with a book, and the book was in circulation for 2 years. Then suddenly they woke up and realized that there was this book around, and they made a charge that the book was a threat to public security because we challenged, the laws and how Islam is interpreted and all that. And we took the case to court when they banned our book. I mean, we asked them to explain to us why you banned the book. They would give us the full reason. So we decided to do a test case and challenge them in court. And we, in fact, we didn't care whether we win or lose, because again, for us, the most important thing was to open up the space for debate, to get our ideas. So any attacks against us, even if we lose a court case, it didn't matter, because it's to build that tradition of public debate and to show people that there are diverse viewpoints in Islam. That was the biggest objective. So we took the case to court and we actually won, because the judge said, what threat to public security, but it's been around for 2 serious, no disorder, so, you know. And then it went to the appeal level just recently, and the appeal court said this is an outrageous defiance of logic. And they appealed again, so now it's going to the Supreme Court. You know, so constantly this kind of challenges, you know, I guess the religious authorities see a group like us as really undermining their authority and what they see as their monopoly on what Islam is and what it is not. You know, and here is like a women's group, you know, not even a men's group, a women's group that's coming up to publicly challenge their authority and their definition. And it's still something that, you know, they can't deal with and cannot accept. So that's why even though they kept losing the case, they are persisting to the very highest level, you know, in appealing it. But I think most importantly, you know, the fact of our existence, what we have done is, you know, that opening up the public space. You know, we've been around for 20 years, you cannot turn back the clock. And what is wonderful is that, you know, now, I mean, for the past many, many years, you know, whenever any issue of Islam comes up, the media would come to us. So we are now seen as a voice of authority to speak out. And for me, that is the most important thing, that the religious authorities do not hold a monopoly on defining what Islam is and what is not. And that there is a level of public awareness that there is diversity of opinions, the possibility for change, for different interpretations, and that people do come to us. And even when we are under, you know, attack and all that, you know, we go through periods of up and down, you know, when we feel relatively safe and when we feel unsafe. We have a legal clinic, you know, people still come to the legal clinic. So we're obviously, the fact that we've been in existence for over 20 years, obviously there's resonance on the ground to the work that we do, you know. So for us, that is the biggest thing. And of course now with Musawa, launching it at the global level and really, you know, doing trainings, production of feminist knowledge in Islam, the international advocacy work, to really build the courage and the will, you know, for women in many Muslim contexts in different parts of the world, to really, you have to fight this battle in public. You know, you cannot do it behind closed doors, behind four walls. It has to be a public fight. And before those public spaces close down, it is important to build this. So for me, that's why we're working with the Arab world very closely. It's just so important that this opening in the Arab world now, that women's groups really begin to engage with religion and really create the culture now. Because, you know, in Pakistan, the doors are closed. You know, it's dangerous. You know, and there are human rights activists and lawyers who regretted not engaging with religion, because now you want to do it, you risk death. You literally risk death in Pakistan. So for me, what's happening in the Arab world is extremely exciting opportunity to create this culture. You know, so it's, and of course you have, you know, in the trainings that we do for women's rights activists, you know, we also raise the issue of the consequences of doing this work. You have to be ready, you know, to face threats, to be hated, to be vilified, you know. But like I said, it really, that gives us the adrenaline to, you know, we know we're doing something right. You know, these people are attacking us because we're making an impact, you know.
Just to follow on the question from Ms. Anwar, I want to get a sense of what you thought are useful models. The U.S. government recently had a program with the Asian Foundation to work with moderate imams and mullahs. Yes, and I was wondering what your thoughts were on that. You know, to have them and their Friday sermons discuss the compatibility between Islamic law and women's equality, but we know that there are different views on taking a human rights perspective versus using the religious avenues. And so I want to get your sense of whether you find that helpful, whether you think that would be effective, and whether you met with, or whether there is kind of a cadre of moderate religious authorities who have been helpful in this fight, or kind of just your experiences.
Yeah, you know, if you can reach out to the imams, that's great. We have problems, it depends on context. In the Malaysian context, it's really, really hard to work with the traditional religious authorities. But there are individuals, so that's what we're working with individuals. So it's not like at the systemic level, but at the individual level, change is definitely taking place because, reality is developing before your eyes and you're ignoring it. It just doesn't work. The disconnect just gets bigger and bigger and bigger. So there is change and there are individuals, traditional ulama who are working with us and they do the trainings with us. That's really important, especially when we do big trainings, to have this male authority figure. But we don't want to, it's important to work with the women, to empower the women, that religion is not this mythical, like it's so difficult to deal with. You have to build the courage. And this is where some of the work that's been done in just working with the ulama, but not working with the women. You've got to work, you work with the ulama, yes, but you must also work with the women and the women leaders to empower them to speak out, to challenge, and to shape the laws in that country and not just depend only the ulama. So because then you're reinforcing the idea of authority, that only the religious authorities, only the ulama have the authority to define the law. So it's important to do both, to work with the male ulamas, but to also work with the women leaders. This is part of the democratization process, and to really, just enforce the idea that religion is not the monopoly of the ulama. So to break that hegemony is important. And therefore, working with women's groups and getting women's voices into the public space is extremely important in doing this. So I know they're doing this in Afghanistan, so I'm a bit concerned. We work with some Afghans and we're doing trainings. We're doing one training with the Afghan Women's Network soon to really, because they realize that concern, that where is their voice in this? They don't have the courage to speak out and they need the training to have the knowledge and the courage to speak out.
I actually think you've got to this question a bit, but I wanted to ask all of you, to what extent you felt that your efforts were dedicated towards changing people's minds versus sort of encouraging those who might have been silent before to speak out?
It's really both. It's changing mindsets, and this is where indicators are so difficult, like human rights indicators. Like, when our donors ask us for indicators of success, and they want numbers. The Europeans are big into quantitative indicators. It's like, how do we measure how many people we have affected with the work that we've done? So we write a letter to the editor, and there's 500,000 readers to that newspaper. So do we say we've affected 500,000 readers? I know people, so it is difficult, but it is about changing mindsets. And because it's about changing mindsets, it's easy to measure when you build trains and schools and toilets and all that. It's very physical and quantifiable. But when it's about changing mindsets, it's very difficult. And when in countries where, especially in non-Arabic speaking countries, where the religious authorities, because they know Arabic, and we, the rest of the population, 80% of Muslims live outside the Arab world, so we all don't speak Arabic. So that means we have no direct access to God. We have no right to understand our own religion by ourselves. But there is that, because we've been brought up to believe that only the ulama, only the religious authorities have the right to speak on religion. So we hold ourselves back. So even though there is this incredible disconnect between what we hear on radio and television in the mosques and the realities of our lives, we don't have the courage to speak out. And what the work that we do is really, in exposing the diversity within the Islamic tradition, the conceptual jurisprudential tools that exist for change, for differing opinions, and in the trainings that we do, what we give to the women and to the public is the fact that that there is possibility for change in Islam. And we also, the argument that we make is, if if in a country where Islam is used as a source of law and public policy, everyone has a right to speak on Islam. Whether you're Muslim, non-Muslim, you're educated in Islam or you're not educated in Islam, it's public law and public policy. And we tell them, you want us to shut up, then you take religion out of the public sphere. Don't use Islam as a source of law and public policy, then we will shut up, because what you say, what you do doesn't matter to us. We will not be punished, we will not be sent to jail, we're not going to have our hands cut off. But if what you do and say, and then that gets translated into law to punish us if we don't abide by your idea of what truth is, then all of us have a right. So this is a very important understanding that we tell, in our trainings. This is not God's law. This is human-made law. This is how religion is used as a source of law. So therefore everyone has a right. Public law, public policy must be open to public debate. If not, you said you change your constitution and turn us into a republic constitution. Then we all migrate, But for as long as we have this democratic constitutional framework, then everyone, has a right to speak. But it takes a lot, the training that we do on understanding Islam from a rights perspective. Training, we bring in women leaders from all over the world for that. And there's incredible demand that we just cannot meet for that training. That, like for many women, it's very life transforming, because for many feminists, secular feminists who've not worked with religion and have rejected religion as a source of empowerment, liberation, possibility for change and all that, they've rejected it because the only Islam they knew is that patriarchal and just Islam. So they said, forget it. It has no relevance to our lives, it cannot be a source of liberation. So the training that we do, because of the realities on the ground, that religion is important for the women that you're trying to help. So how can you totally ignore and negate it? Your trainings on gender equality gets challenged, but Islam says this, but Islam says that. And I get that even in the US, when I talk in the US or in Britain, you have domestic violence law that makes domestic violence a crime, but when the police or the social services go to the house, and the guy opens up the door and says, this is our culture, this is our religion, they don't know what to say, what to do. So the rights and the services that are afforded in these countries are denied to the Muslim women because of culture and religion. So training women on how to really deal with this is extremely important. And for many women, they say that the trainings that we do is really very life transforming, because it's not the mainstream Islam in terms of this is an Islam that recognizes rights, that recognizes justice, that recognizes the possibility for change. And for many women, this is really important. And we actually do get a lot of, not a lot, but a number of emails from young Muslim women in the US, who say that, the work that we do is important because they can comfortably make the claim that I am a Muslim and I'm a feminist. Why do we have to choose? That if I want to be a feminist, I have to deny my identity as a Muslim. I want to bring both identities together. And for many young women today, that's very important.
One last question.
Hi, my name is Diana Essex. I work for a nonprofit based in San Francisco called Asylum Access that seeks to transform the refugee rights landscape in the countries we work in. And one of the tools we rely on is strategic litigation. And I had a question for Ms. Northup, generally about the use of strategic litigation and this idea of creating an effective political space. I was curious about the decision to focus on to use a middle-income country for strategic litigation, so that a lack of resources wasn't the first line of defense. And I was wondering if you could speak further to that decision. Was it a hard one, and what were the other criteria that you used? And is the expectation that the precedent set by that case you described would be harnessed for impact in countries below and above the building network?
Yeah, it was, it wasn't a hard decision to make at all. We knew that maternal mortality in countries that had resources to address it was and the idea was, you know, from there to be able to build it out to others. So we thought that was, you know, incredibly important because, again, it's to shift the frame from both, you know, this is women's inevitable plight and, oh, the government doesn't have enough money to do this, you know, we just don't try our best. So it was really important to put it in context where something else is going on. It's not about the fact that there's not money here to address this. It's the fact that these women's lives are not seen as important enough.
One last question.
Good morning. Actually, I don't have exactly question towards you. I'm Farjana Yasmin. I'm from Bangladesh. I'm a judge over there. And here I'm studying in Golden Gate University School of Law as a fellow of International Women Justice Association. Actually, I want to add something with Jana Anwar because she concluded her speech saying like this, that the initiative for changing the law should come from the government. But my 4 years experience in civil courts in Bangladesh, especially for polygamy and child marriage, we have statutory law as well as Sharia law. And for stopping polygamy and for restraining child marriage, though there are strict laws and they are punishable under our law, still, you know, sometimes the parents, they hide the age of their girls and they get married. So it becomes really very impossible, it becomes very tough for the local government as well to stop the marriage. So this I feel in the court when sitting in the Islam doing judgeship and other words that actually it's not the law. Something we have to now focus on the law. Like we have to change our mind and the initiative or the respecting the women or other issues should come from the men's heart and also from the women's heart. And we have to respect ourselves. As we never go back. We have to go forward. We have to ask for our right and everything. And so for this reason, actually we have to work together. And now our approach should be from the people, not from the government. Because government is doing many things for us. Because we have statutory law, Sharia law, many things, but still there is problem. So it's, the problem is in there on the right one here. Yeah, your lady. Sorry. So actually, we have to change our mind. I don't share this. Okay, thank you.
No, I mean, I absolutely agree. I mean, the law just sets, it's important to have a law because it sets a standard, yeah? But after that, that's just the beginning. After that, all that public education work that needs to be done, you know, how do you bring the law, you know, how do you get the social, cultural values to change, you know, to bring about the real change. You may have rights, you know, the de jure rights, but you don't have de facto rights because the community doesn't support the ability of the woman to petition for divorce, to challenge her husband's, you know, polygamy. You know, in fact, the first letter to the editor that we wrote was on the issue of polygamy because the law on polygamy in Malaysia is wonderful. There are all these conditions which actually make polygamy, if the courts really enforce its conditions for polygamy, it makes polygamy almost impossible. Yeah, and but the courts don't. You know, so the judges don't enforce that law too. Even all they just look at the financial ability of the husband to support a second family, but the ability of the husband to treat the wives equally, to cause no harm, nobody measures that. You know. But many women don't challenge, you know, when the husbands take a second wife without fulfilling those conditions, don't challenge. So, but there's one brave woman who was the first woman engineer in the electricity board in Malaysia. She challenged it, and she won her case. You know, so we took that off. So this is again about in terms of the strategy of creating the public voice. How do you use a case that's in the public space to then get your voice heard? So we use that court judgment to write our first letter to the editor, applauding the court judgment and basically saying that, look, polygamy is not a right, not a divine right in Islam. There are many conditions, the context in which the verse of polygamy was revealed. You know, so we use that to really support the court judgment and to really
build an understanding in the public that this is not a man's right, a divine right in Islam. So that public education work is extremely important before rights can really become, de facto rights.
One of the things to keep in mind, and I'm looking at your title, right? Advancing Gender Equality Through Human Rights. What we are looking at when we talk about gender equality is both structural and behavioral change, right? And we are only paid to do one type of change, right? And it's not just resources, it's time included. So actually human rights framework is the key to looking at both, right? And I think that's why I'm talking about, respect, protect, and fulfill, right? Not just to stop at respect. If you're serious about gender equality, then we do bring in structural and behavioral change, and we look at, and that is allowed through the framework of respect, protect, and fulfill. And I think we cannot undermine that, and there is a way in which that we can actually measure it. So that's a good thing.
Right, and I would also just say that sort of brings us back to yesterday's news panel, which was about claiming rights and how important that is. And because at the end of the day, rights aren't for lawyers,